This video lecture is recorded for Constitution Day. My name is Kenneth Fernandez. I'm a professor of political science at the College of Southern Nevada in the Department of Social Sciences. And I'll be talking about the famous case Marbury versus Madison, which established the precedent of judicial review. Now, what is judicial review? Well, it's the court's authority to determine whether legislative, executive, and even state actions violate the Constitution, and is a very important component to the concept of checks and balances of our political system. Yet this power to invalidate actions of Congress, of the president, or other states is never mentioned in the U.S. Constitution. Yet the concept of judicial review, existed prior to our ratification of our Constitution. Many state courts had the power to overturn state laws, although they may not have done it very frequently. They had that power prior to the ratification of the federal U.S. Constitution. And many founding fathers might have assumed that the Constitution just placed this power in the courts. Hamilton wrote in the Federalist Papers that the judiciary would act as a check on the other branches of government by interpreting the Constitution and ensuring that laws and actions adhere to it. So really, I think many founding fathers assumed that the court should and would have this power of judicial review. Yet it's never mentioned in the Constitution. If we go back to earlier times, to the colonial period, we see a system of courts in the colonies that is very weak. They lacked independence. They were heavily influenced by the royal governors that are appointed by the king, And so colonists were very skeptical of the authority and impartiality of the court system during colonial period. However, after the American Revolution, when the colonies gained their independence, and we started to form our great nation, the state courts slowly began to be more independent and even occasionally asserted the power of judicial review. And between 1787 and 1803, the historical records suggest that state courts invalidated more than 20 state laws, helping establish the tradition of judicial review. But it wasn't until the famous court case of Marbury versus Madison that the power of judicial review was officially established as a power of the U.S. Supreme Court. I do want to note that there's an interesting sidebar here in that we will be talking about the second president of the United States, John Adams, and the third president of the United States, Thomas Jefferson. Adams, not wanting the next president to be able to nominate and appoint a Supreme Court justice, Adams, a Federalist, and the Federalist-controlled Congress ended up passing a law reducing the size of the Supreme Court from 6 to 5, preventing Thomas Jefferson from being able to put a Democratic Republican nominee for the Supreme Court. I want to note this just to show the political dynamics, that are happening in 1803 and the political dynamics that are happening today, Who sits on the Supreme Court, in 1803 and who sits on the Supreme Court in 2024 is a contentious political battle. And we've been battling this out for well over 200 years. So if we look at sort of the main characters in this very interesting story behind this case, we have John Adams, from left to right, moving from top, bottom, top, bottom, top, bottom. We have John Adams, second president of the United States, He loses re-election bid, and is replaced by, if we go down one, Thomas Jefferson. If we go up, in the middle there, James Madison. James Madison is the Secretary of State of the new President Thomas Jefferson, Go down, William Marbury. He's the name of the case. He's the one who's suing, He is suing James Madison, the Secretary of State of Thomas Jefferson. Who hears this case? It's John Marshall, furthest left. John Marshall has an interesting position in that he is both at the same time Secretary of State of John Adams, right, the second president, and appointed Chief Justice of the U.S. Supreme Court. Right? These are sort of the five major players in this very interesting story of how judicial review became officially a power of the U.S. Supreme Court. So, John Adams, second president of the U.S., he loses a very contentious election to his vice president, Thomas Jefferson, in 1800. And as we note, as we remember, John Adams was the vice president of George Washington. Adams is a Federalist who believes in a strong federal government, and Congress is controlled by a majority of Federalist members of Congress. And near the end of John Adams' tenure, right, just a few days before he has to leave office and hand over power to Thomas Jefferson, the Federalist-controlled Congress passes the District of Columbia Organic Act of 1804. Right, it officially makes Washington, D.C. a city and creates 42 Justice of the Peace positions, for the most part to reward loyal supporters, because D.C. was not that populated and didn't really justify 42 new Justice of the Peace positions, but they wanted to create these positions to reward loyal supporters and place Federalists into this judicial system. So with just a few days to fill these positions, John Adams, right, along with other Federalists in Congress, create a slate of nominees, 42 nominees, to get approved by the U.S. Senate. They're approved in a matter of days, and John Adams races the clock to sign the 52 commissions, hand them over to his Secretary of State, John Marshall, for him to place the seal and deliver these commissions to these individuals, right? Racing the clock, right? Ironically, Marshall is both Chief Justice, right, of the Supreme Court and Secretary of State, right? The problem is that Adams and the Federalist Party took so long in passing this law and picking the individuals that they didn't have time to deliver all 42 commissions. The president signed all of them, and all of them were sealed, but not all of them were delivered, right? Now, depending on the historical record, right, supposedly 32 were left on the desk of John Marshall when James Madison took over as Secretary of State. And Thomas Jefferson delivered 25 of them, right? Leaving 17 that were not delivered. And one of them were a commission to be Justice of the Peace for William Marbury, right? A 5-year position, not a lifetime tenure like other federal positions. This is a 5-year position, and a very modest position in that they would notarize documents and hear small minor cases, right? But still, right, if you were promised a job and then it was not delivered, you probably would be upset as well. And therefore, William Marbury sues the government, right? He sues for his commission to be delivered. And he goes directly to the U.S. Supreme Court to demand this. Unheard of today, right? But at the time, right, the Judiciary Act of 1789 gave the Supreme Court the power and jurisdiction to issue writs of mandamus, right? A writ of mandamus is a court order compelling a government official or a lower court to perform a duty that is legally required of them. So in this case, right, Marbury says this commission was signed by the president, it was approved by the U.S. Senate, right, sealed by the Secretary of State, and therefore must be delivered. And that's what Marbury's attorney argued. Did Marbury have a legal right to this appointment? Absolutely, right? He was legally nominated by the president, confirmed by the Senate. That confirmation was signed by the president and sealed by the Secretary of State. It just didn't get delivered, but it still remained on James Madison's desk, right? Just because we have a new president doesn't mean all other actions are null and void. And the other thing that the attorney addressed was, can the court correct this error? Yes, it had the power to do so because the Judiciary Act of 1789 gave the court the power to order these government officials to do their legal duty. But there was a dilemma, right? Chief Justice Marshall, arguably the greatest Chief Justice in U.S. history, right, knew that the court didn't have substantial power, and that theoretically, if he rules against Jefferson and Madison, that Jefferson could theoretically ignore the ruling, right? But Marshall didn't want to approve of Jefferson's defiance in refusing to deliver these legally binding documents, right? So what does Marshall do? He realizes, right, that he's stuck between a rock and a hard place. Alexander Hamilton notes that the judiciary, right, has no influence over either the sword or the purse, right? The president is commander-in-chief. He has the power of the sword. Congress is in charge of the federal budget. They have the power of the purse. Supreme Court has power over neither. And Hamilton argues, it may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm, even for efficacy of its judgments. Right? Marshall is aware of this, doesn't want to approve of Jefferson's order to Madison not to deliver these commissions, but doesn't want to look weak and have a judgment by the Supreme Court ignored. So in the court writes an opinion written by Marshall, right? And that's problematic because in today's sort of ethical considerations of judges, it would be problematic to be the Secretary of State who sealed these commissions, right? And then also the Chief Justice hearing the court case that these commissions should be delivered. A judge would normally recuse themselves, but Marshall was not going to do that. In fact, historians believe that Marshall was writing up this opinion even before, right, the justices had even voted on it. But it was unanimous, right? Unanimous that Marbury was entitled to the commission. But here's the catch. The U.S. Supreme Court actually didn't have jurisdiction of the case. Marshall argues the Constitution is clear regarding the cases that can go directly to the U.S. Supreme Court. Those are cases involving diplomats, and those are cases involving disputes between states, like if Texas decided to sue Nevada, or a state suing the federal government or vice versa. Those are cases, right, involving original jurisdiction. They go directly to the U.S. Supreme Court, right? In these types of cases, the Supreme Court is the first and only court to hear the case. It does not come from a lower court appeal. All other cases, other than original jurisdiction cases, must be heard on appeal from lower courts. They're heard by other courts. So Chief Justice Marshall and his fellow justices unanimously ruled that Congress, right, in drafting the Judicial Act to allow the court to give writs of mandamus and act, right, in this original jurisdiction capacity, that they had erred. They had expanded the jurisdiction of the U.S. Supreme Court by a congressional law, when in reality, you would have to amend the Constitution to expand the jurisdiction of the U.S. Supreme Court. And I actually think Marshall makes a very good point that that's true. So the Supreme Court rules that Article 3 of the Judiciary Act is unconstitutional. Not the entire act, but that part that expands the original jurisdiction of the U.S. Supreme Court, right? Thus, by ruling that this congressional action is unconstitutional, the court creates this precedent of judicial review. The irony is that by ruling that Congress cannot expand the jurisdiction, it actually gives itself expanded authority to invalidate laws. Now, one thing that's been asked is, could Marbury versus Madison be overturned, right? It could. It is a well-established precedent, right? And this doctrine of stare decisis, which means to stand by things decided, gives significant weight to legal precedents, especially those as long-standing and integral as this one, right? That doesn't mean that a president could nominate and get confirmed Supreme Court justices that want to end judicial review, right? Just as Donald Trump nominated and got confirmed 3 conservative judges that helped to vote to overturn Roe versus Wade. It could happen. Yet political scientists and economists have this theory. Some people like it, some people don't, but it's a fairly influential theory, rational choice theory, which suggests that individuals are self-interested and strategic. And I even think Marbury really is a good example of rational choice theory. Marshall was a Federalist and wanted to rule against Madison and Jefferson, but also knew that the court might look foolish by picking a fight with the president and losing. So in a self-interested and strategic manner, right, Marshall creates this precedent of judicial review. He rules sort of in favor of Jefferson and Madison, right? And that was actually surprising. Madison, William Marbury's attorney, was alone in the court, basically giving this argument. Madison didn't even send a representative to argue his case. Madison assumed they're going to lose the case. Marshall ends up surprising Madison and Jefferson and ruling in their favor, saying, yes, Marbury deserved this, but the court can't do anything. But in a self-interested and strategic manner, creates a precedent of judicial review. So why would a future court and future justices take away this important power of judicial review? It would dramatically weaken the institution of the courts. So it seems like an unlikely scenario, but not impossible. Right? Citizens could also urge Congress or the states to amend the Constitution to clearly state that the Supreme Court does not have the power of judicial review. Right? Maybe, right, the overturning of Roe versus Wade in the Dobbs 2022 case makes so many people mad that they want to take away the power of judicial review. Yet, the widespread belief in the principle of checks and balances, right, and its importance in the longevity of our democracy and its protection of our civil liberties, I think that's an unlikely scenario as well. And also, it's very difficult to amend the Constitution. Not counting the first 10 amendments included in the Bill of Rights, we've only amended our Constitution 17 times. And so again, I think judicial review is here to stay, even though it's never mentioned in the U.S. Constitution and only really established through precedent in this famous case. And it's famous because prior to this important case, the Supreme Court was a young and not well-regarded institution. In fact, a number of individuals in the early part of our U.S. history, nominated by George Washington and Adams, they refused to serve. That's unheard of today. If you were nominated, right, to serve on the U.S. Supreme Court, it would be one of the highest honors and probably one of the greatest jobs, given that it is lifetime tenure. And so this decision really, right, gives the court important political clout and redefines the court for years to come. Right? And Chief Justice, because of this, in part, he has a long, interesting career. Chief Justice Marshall, the fourth Chief Justice in the court's history, and the longest serving Chief Justice in U.S. history, 34 years, right, is considered, as I mentioned earlier, the greatest Chief Justice in history. In this case, he avoided a confrontation with the President of the United States, but also sent a signal to the President and Congress that the court would not sit on the sidelines. I hope you found this lecture interesting, and happy Constitutional Day.